And we are live. Hello.
Hello.
How are you?
I'm all right. How are you?
Um, I'm really asking. So I felt like
Good.
that was like the I'm passing you in the elevator. Like, yeah, I'm all right. I'm all right, girl. I'm all right.
Finding
That's fine.
you. Finding you.
Yeah, I'm blessed and highly favored. Blessed and highly favored.
Praise the Lord, saints.
No, I'm really asking. How are you doing? We are back um after election 2020 and all that is and has been and apparently continues to be and such like and so on. And we are in week 10,749 of uh, COVID distancing, and also it's November somehow,
The
and
middle of.
not quite. I'm not ready to rush it that far. We're in the first third. We're one third of the way, which is not the same as half. Um,
Hold on to your bangs. Thanksgiving's 2 weeks from tomorrow.
uh huh. It is November 11th. That puts us at approximately one third of the month. I'm taking this. I am taking this. This
That's fair.
I will have one third because
I'll back up.
I can't
I'll
handle the
talk
speed
again
of
on
time.
Saturday.
Right? You know what? If you call me on Saturday just to tell me that, my response is going to be unfriendly.
It's like that little cartoon where they reach through the phone to throttle somebody.
Okay, I'm
The
not a
little
throttler.
vibrations are wrong.
You know I'm not a throttler, but I know my words can get a little sharpish. I'm just forewarning you that it will be sharpish.
Heavy on the sharp, right on the ish.
Right. So, I mean, in such a time as this, it seems like every week we come on Wednesday and we're like, in last week's episode of Life in 2020, right? Something happened. Oh
Amen.
goodness. So how you doing? My sister's here. Hey Danielle. Thanks for being here, honey.
I'm all right. I really am. I laughing when you're saying that, like the such a time as this, and it's like every week feels like that.
Mm-hmm.
I saw one of those little TikTok memes. Like I don't have the
You're on
TikTok, but
TikTok?
I don't know. Heck no, I don't have no TikTok. So much so that if I went to look for the TikTok, I don't even know what the icon looks like for TikTok. I at least know what the one for Snapchat looks like. I don't have it, but I know what it looks like.
The reflex was just it just like no. Like, who are you talking to? What are you asking?
Right.
Oh goodness. Okay, sorry. Okay. Okay, I have gathered myself. Okay, I
I
am a whole
appreciate.
adult professional. Look at, with my adult professional glasses. I'm back. I'm back.
So, I was saying, so thankfully, the other kids know how to get their little TikTok things onto the Instagram, which I do know how to use and have.
Okay.
And I saw one where it was the angel Gabriel was in charge of the project management and was talking to the various beings and asked Lucifer, "Are we all set for the 2020s?" And he's like, "Wait, the 2020s? I thought you meant the year 2020." And Gabriel was like, "No, I meant the decade of the 2020s." And he's like, "Oh, shoot." And Gabriel was like, "God is going to kill me." Because it really does feel like a decade's worth of stuff
Has happened
somehow
in
found itself
2020.
into this one year.
You know, you know. And so,
That part.
well, I
So,
am glad that it is well with you.
yeah, no, I'm getting my rest, eating my foods, taking care of myself, moving around. I'm still tired. The seasons change, the weather change. I'm like, who did he what now? But I mean, if that's the worst I got to complain about, I'll take it. So that's that's how I be. How you be?
Um, it is well with me. I am, it is what it is. Like, I think that's kind of where I am, similar to where a number of other folks are from day to day. It is, you know, things change sometimes from moment to moment,
Part.
but but it's all good. Or at least that's what I'm claiming. I am. I got a pretty strong reminder this week, a pretty strong alert to pay closer attention to how I'm fueling myself, like what I'm eating and all of that, because I ate something on Monday that pretty well nearly just shut me down. Like it just took all of my energy, which is 180 degrees different from what
We
food is supposed
expect.
to do. Like
Yeah.
it was just like like and you're done, which made the rest of the day really challenging. Um but anyway, I am attentive to and appreciate the reminder to say, hey, how are you feeling yourself? What's going in there? How's that working for you? Um, so that's it where I am. Now we talked all about your business. Who are you? What's your name? Why are you here?
Puddin' asked me again. I tell you the same. Uh,
Wow, wow, wow. So okay. So we're reaching back like that today. We're just okay. All right. Yep. Sure. Okay. Well, my name is Jill. I am one half of the Dahlia Law Group lawyer team. Dahlia Law Group is a law firm in Oakland where we do the work of legacy. Um, the stories of people's lives, the monuments of people's lives, the things that are important and available only because you were here. We use the tools of legacy and estate planning, of probate, of litigation related to those areas to carry out that work of legacy. But legacy is the work. Puntang, are you doubling down on that, or is there a different way you want to be addressed today?
well, since the papers that we submit to the various people say different, so as to not create any confusion,
Okay.
I'm Alicia, the other half of the Dahlia Law Group lawyer team.
So this is what it is today. Welcome, welcome.
I'm thinking of the malpractice carrier going, be like, now who is this Puddington? That is not on the
That is
application. We do not have coverage for that
right.
person.
It's like I didn't see that on the renewal. I didn't. Hmm. Hmm. So, for those of you who have been with us on the past couple of weeks, you might remember that last week we were just peopling. Like we were just pressing pause and just being easy with ourselves and with you and extending that invitation broadly. So last week we did not talk about the substantive legal things, but you'll remember that the week before that we started a conversation about tips on how to get your conservatorship done the first time. So we realized that we had more information than we had time to really discuss in one episode. And so we promised that we would come back with the second half or with the other half of that information in the next episode. So that's what today is. That is what today is, and I'm gonna do my best to, excuse me, to run us through a summary of where we left off, kind of what we covered before, and then we'll pick up with the additional details today. But before I do that, so I'm going to run us through the summary. Then Alicia is going to start with the information from today that's unique to today, and I will try to drop some bullet points, some summary points into the chat while she is doing that. Before we get into all of that, if you have any questions, if you have any things that sort of came up for you in the previous episode or even from last week, whatever. We just want to talk to you. That's part of the reason we're here live. So please feel free to drop us questions, thoughts, concerns, to talk to us. We see that stuff and we can talk back to you. And there was one other thing I was going to say, but now I've forgotten it. So there you go. So here's where we are. Here's where we left off to kind of get us into this conversation today. We had already, we sort of, when we were talking about probate before, that started a conversation directly with fiduciaries or would-be fiduciaries. And you will remember that fiduciaries are the people who are in charge of handling somebody else's stuff. That's a summary way of thinking about what fiduciary is. So we started talking about conservatorships, and that last episode we were reminding you of what a conservatorship is, understanding sort of what conservators do, and then going over the conservatorship procedure steps, including tips for things like how do you figure out even when a conservatorship might be needed. We talked about that. We talked about gathering information to support the conservatorship petition, because remember, a conservatorship is a court process that does two things. It removes an adult person's ability to make certain decisions for themselves when they've lost capacity to do that. And it puts somebody else in charge of making those decisions. And those decisions can be about money, they can be about personal decisions like where you live and that sort of thing, or it can be both. So we talked about the stages of conservatorship, and where we left off was we had started talking about the conservatorship filing in court itself. We talked about what type of conservatorship filing you might be doing, and got all the way up through the part where we started talking about, where we talked about notices, right? So where we're going to pick up today is what happens after that initial filing and notices. If you have questions about, what is she talking about? What is this initial filing? What are these notices? What is any of that about? Just go back 2 episodes, because last week was sort of an off episode. So just go back 2 episodes and get that conservatorship information, and then this will make a whole lot more sense to you, because we're picking up from there. Did I leave anything out?
No, I think you got it all. That's what I remember, yeah.
Excellent.
So picking up from where we left off, dealing with after we have the initial filing in place, you file it, the court accepts that filing, and then they're going to schedule it for a hearing date. Currently in California, what we're talking about for that hearing date is a period of time that's going to be about 4 months out. And so natural question is, why do we have to wait so long? What happens in that 4 months? And so the important thing is, it is not, that 4-month period is not just a sitting on hands, nothing happens point. That is where some of the work is being done to help with what is going to end up being decided at that hearing. So during that time, there's going to be a period for an investigation and assessment. And so what is happening at this point is, remembering in Jill's recap that she um, emphasized that this is a court process that we're going through. And so, because the court is both stripping somebody's rights and putting another person in charge, some of what needs to happen is, number one, ensuring that the stripping of rights is the right thing, that that person actually understands what this means, and if they have something to say about it, to make sure that they have an avenue to be heard about that. Also, the person that we are about to put in charge, making sure that that's an appropriate person to do that. And so this is very much the court saying, if I'm going to take jurisdiction over this thing and be in charge of it, I need to do my due diligence to make sure that this is the best thing for this person. And so, in that process of that investigation, the few of the things that are going to happen, number one, the court is going to make some appointments of some people. That is going to happen as soon as that filing happens. So number one is, if the person who we're trying to take care of in this instance, in this stage of things, is called the proposed conservatee. They are the person that's going to be under the power of this conservatorship. And so if that person does not already have a lawyer that represents them, the court is going to appoint somebody to represent that proposed conservatee. And it's important to keep in mind that if you are the person that is trying to help this person, so you're the family member trying to help mom or dad, and you say, well, great, I got a lawyer to help me do this, so we don't need that. This is different. The lawyer that represents you as the person filing to be the proposed conservator cannot be the lawyer for the proposed conservatee. Your interests are different. And so the lawyer that the court is going to appoint, if the person does not already have one, their job is to speak to that proposed conservatee and go to court to speak on their behalf. So that's one thing that's going to happen in this investigation and assessment period. And that lawyer is going to meet with that proposed conservatee to assess the need for this conservatorship so that they can make a recommendation to the court. But also, if the proposed conservatee, for instance, wants to object and says, I don't think I need this, then that lawyer's job is to get an understanding of what their client is saying so that they can present that information to the court to be considered. Another appointment that's going to happen right away is going to be of someone called a court investigator. The court investigator is exactly those two words. It is a person that is appointed to conduct an investigation about this situation, about the needs of this person, the person who's asking to be appointed, all of the background on these people, and they are an employee of the court. So they don't represent any of the people's interests that are involved in this particular filing. They are just supposed to be conducting an independent investigation in all directions on this thing so that they can report back to the court so that the court will have the information that it needs to to make the appointment as needed. So thinking about the folks that are involved here, and we talked about, let's get some tips to get it through on the first time. So one of those to know is, for instance, this court investigator, there is a charge that is associated with that. So in California, that court investigation fee is a minimum of $800. And so knowing that, one of the things that you're going to have in that initial filing package is there's going to be a request for some background information for the person that is applying to be the conservator, that they need to check off on some certain things. And so when you are completing that document, know that that's the starting point that the court investigator is going to be using to conduct that investigation. And so one of the things that will help you greatly for this investigation and assessment period is be as truthful as, tell the truth on that form. And even if there's a question that you don't have all of the details for, so maybe it's have you ever had this in the past? And you check yes, and it says, give me more information, and you don't remember all of the details, but you know that the answer to that is yes. Make sure you check that yes box, and it'll tell you to attach something with the details and put as much as you remember, even if it's not chapter, verse, and subverse and all of that, whatever you got. So if it was around 20 years ago, this happened, put it on the paper, because the investigator is going to look up all of those things. And what you don't want to have happen is for them to find it, because it's a different situation of you did not disclose it and you were not truthful on your form versus I didn't have a lot of details, but I told you what I remember on the form. So that's a tip for that investigation and assessment period that you can do to help yourself. Another is going to be ready to assist with coordinating visits. So the court investigator is going to have to meet with the proposed conservatee. They're also going to meet with the proposed conservator. If there is a proposal to change the place of residence for that proposed conservatee, then the court investigator is likely going to want to see the place where you propose to have them living. And so, if that is, for instance, in a private home, whether it be your home or someone else's home, then being ready to do what you can to coordinate and facilitate those visits, knowing that you just might be involved for scheduling and access purposes, but then you will be dismissed from the proceeding. So you're not going to be in the visit. But if, for instance, your loved one that you're trying to help doesn't answer the door for strangers, then letting that court investigator, for instance, know they're not going to answer the door for strangers. So if I go with you, so that when they look through the peephole, they see me, and then I can help facilitate them allowing you in and knowing that you are a safe person to allow in the home, for instance. And that might be something that you would want to do, and being prepared to do that, because thinking about that 4-month time period, the more of that can get done and facilitated easily and as quickly as possible puts you on a road to the court having all of the information it needs at that decision time. Is the other tip about this is, if you are like, oh, well, if we just don't get to it, but they see that this person needs it, then they'll just do it anyways. It does not work that way. If the court gets wind that we don't have the investigation done or this is not done, they're not going to just push it through. In all likelihood, they're going to continue your hearing date. So you're going to have to wait even more time. And sometimes that can happen in a place where the court will just do that when they see all of the information is not submitted. When they're preparing for the hearing date, they will just move it to a new date. So it's not, I'll go to court and explain why ABC XYZ is not done, or talk about the problems. You might not even get that opportunity. So knowing on the front end and helping with that as much as you can is going to help you get this through clean and smooth.
Also, it is a just step back for a second and think about and just remember what's happening here. The conservatorship filing is asking the court to take away an adult person's rights and ability and their legal abilities to make decisions for their own self, whether that is about where they live or who their friends can be, who their doctors are, or how they handle their money or their property. So thinking about that, it is really taking away some abilities for an adult human to sort of to be in the world as an adult human, right? And that might be the right thing, but that's what this whole process is designed to help figure out. So the court is naturally going to look into what you put in the papers, right? And to look into the situation that you're saying it has led to this, right? The situation that has led us to the courthouse that to take this drastic step, right? And so the more easily the court can do its investigation, to check and see, all right, well, what actually is going on here, and is a conservatorship really necessary? Is it necessary to take this person's rights away and give those rights to somebody else, or is there something else that we can do here, right? And so the a conservatorship is coming up. It comes up when somebody needs an extraordinary amount of care. And so you want to, like Alicia said, really be thinking about how you can get this done efficiently, because the longer this takes to do, the longer the person who needs the help that a conservatorship can provide, the longer they don't have it. Right? So there's that. But also, the more easily the court can get its job done, the more likely it is to actually grant the petition. That's the other thing. Because if it continues to be difficult to get all of these steps done, then the court is more likely to just dismiss the petition and say, you know what, if it's not that serious, then it's not that serious. So,
Yeah.
So we can just go ahead and get that out of here. So that in real practical terms, there are, the legal steps that you have to take. But in real practical terms, what's going on is you file the papers with the court to say, hey, there's an extreme situation going on and this person really needs some help. And the court immediately tags in and says, oh, really? Somebody needs help like that. Let us get in there and see what it's all about. And so, and let's see if we can actually get them the help that they need.
Yes. Then another thing that's going to be happening in that assessment period, which you may have done this already. I know we talked about in the previous episode, we talked about it in the area of getting your documentation ready for determining whether a conservatorship is needed and having it in place. But if you were just in the prep stages and haven't actually hit go on the action item, it needs to happen in this stage and as early as possible in this stage, is that there is a particular court form that the court will be at least in California, that the court is going to be looking for a medical assessment for the need for this conservatorship. And so sometimes it can happen where you have the filing, that you do the initial filing, and you might have where the doctor maybe wrote a letter saying that this person is incapable of managing their own affairs, and it's on the doctor's letterhead and signature. That is not enough. So the court is going to be looking for their actual form. Here it's called a capacity declaration. And so it's like a 3-ish page form, and it's asking the doctor to do different testing and assessments and assessing the level on a particular scale that the court has set for that person. And so if you had not already done that with your initial filing, that is a thing that you want to get on right away after you get that hearing date assessed, because it may involve getting that person to the doctor for an exam and getting that form back from the doctor. And so letting yourself have as much time as possible for that, because for all of these various pieces that we're talking about, the visits, the investigation, if there's follow-up that needs to happen on the background, getting this capacity declaration, and all of that stuff, all of that has to get filed with the court in advance of the hearing date. So we don't show up in court with it at the hearing date, because the court will have reviewed it already before you get there. And so knowing that, thinking about not just that 4-month date as your target deadline, but backing out a couple of weeks from there before that, so that you can make sure that all of the things that you need are submitted in advance.
Yeah, we talked a lot about that last time, and it's because it's really so important, because so much of the information that you need to supply to the court, that you need to give to the judge, has to come from other people. And so, you know how it is. It's not, other people's priorities are not always your priorities, right? Just because it's an emergency and is important to you or to me doesn't necessarily mean that it's an emergency or it is as important to them. Not because, not necessarily because people don't care, but because there's a lot of emergencies out there, right?
Yours is not the only
Yeah,
emergency on the
everything
list.
is competing to be the number one priority, and so the things that end up getting floated to the top of the list are, I mean, what do you do when you have a lot of work to do? What gets done first? Usually the easiest thing, right? The thing that you can just knock out real fast and put a check mark by it, right? Those are the things that tend to get done first. Same here.
So true. So that takes us to our next stage in the process, which is the appointment process. And so the appointment process is you got an appointment at the courthouse. So that's the hearing part. So that is where the court is going to consider that petition and all of these various pieces of information that have now been submitted in advance. And so we're talking about the submitted in advance and making sure that you have all of these things in front of the court before that date. And one of the reasons for that is because the court will often publish notes in advance of that hearing date. And so one of the tips is to start checking a good 2 weeks in advance of the hearing date. On most court calendars, there will be some mechanism for checking the status of your case online. And so you'll want to start checking that for your specific case online, because when they are ready, the court will publish these notes. And what those notes can help you with is if there are any things that need to be fixed or cured or something that the court sees is missing in your petition, it will say so in those notes. And so sometimes what will happen, and when everything is firing on all cylinders, is those notes get published. If you see them right away, you can see what things the court is looking out for and need to be fixed, and get it fixed in advance of the hearing date so that you can still keep things on track. And so in an ideal world, they email those notes to you, but that does not always happen. And so that's why about 2 weeks out, you'll want to start checking every day, every other day to see for when those notes are getting published. That will also give you an idea for, even if it's not something that you need to file in advance of the hearing, if there is some concern or question that has been noted that maybe needs to be addressed in the hearing, you can spot that so that you can be prepared to address that issue when you go to court, and know that you'll have, if there's supporting information that you need, additional information, contacts, whatever, that you will be there and be prepared for it. Because the more of that you have ready to speak to at the hearing date, get you that much further on getting your petition granted that day, instead of, oh, I didn't know that you needed that, I need to go and get that. And then what the court is going to do is say, well, we'll go ahead and continue this hearing date. And while you might be thinking, oh, I can have it by tomorrow, the court schedule does not work like that. So their next hearing date might be a month or more away, which means your person is still not getting that help, because you can't do anything in that meantime other than gathering that information and being ready to come back again.
Yeah, and this is a place where sometimes people get really frustrated because there can be the technical requirements that the court or the judge is insisting that you do, and it might seem like it's just being technical for technical sake, right? It might seem like it's just a signature, or it's just a form, or it's just a note. I mean, we have had, to give you an example, we have had actually, I was in a hearing, what was it, last week? The week before? What is time? Who knows? I was in a hearing recently. Actually, it was on election day. I was in a hearing and somebody's petition got bounced because they didn't have the zip code on a notice that,
Oh, man.
that needed to show the address that they sent it to. Now, they were able to deal with that. Something like that they were able to deal with pretty easily right there during the hearing. But I'm raising that example to say that when you're doing this, particularly when you're doing it on your own, and you're not represented by a lawyer, that can look like, seriously, are you really talking to me about a zip code? Now, you know good and well that the post office is not going to deliver something without a zip code, or if the zip code is missing, then the post office will supply it. They have all the zip codes back there. Like, why are you talking to me about this? Right? And so it can feel hyper technical. And part of it is because it is, but also part of it is because of what we're doing, right? We are taking away somebody's individual rights to manage their own self. We want to make sure that everybody who was entitled to know about it knew about it and had a chance to say something about it. We want to make sure that all of those technical requirements are met, because while you might be, applying for a conservatorship for all of the right reasons, right? Really trying to help somebody. You all watch People's Court like I watch People's Court. Y'all have seen people out here with shenanigans and foolery that are, trying to get a hold of somebody's money or property or something like that, or their ability to make decisions for themselves because they have, because they're trying to steal, or they're trying to hurt somebody. Elder abuse has a name and a definition, and and consequences for a reason. So not everybody has the same type of intentions that you do. So I just wanted to make that note, because it might seem like we're harping on these hyper technical things, and one, we are, and two, reasons.
Yeah, no, it's an important note, and it's one that sometimes it can get even more frustrating when everybody is in agreement that this is in the best interest. So all the families in agreement, we're all on board, and we're just doing this so that we can get the legal documentation in place. And it feels like a lot of process, but the process is the same whether we're all in agreement or we're in conflict about this. It's the
Right.
same process. The court is using the same assessment. And so just trying to smooth out these things to just make it like, even though it's process, if we can just get it through and rolling nice and easy, like, let's do it that way.
Yeah. 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 Do you want me to talk about reporting and accounting?
Sure.
Okay. All right. So after you are appointed, after you're appointed as conservator, so the person who's going to be stepping in and making the decisions on behalf of somebody else, if you are in charge of any money or property for that person, then the first thing you're going to have to do, the first requirement that the court is going to have, is that you file an initial accounting. The purpose of this initial accounting is to tell the court, right? To tell the court and everybody else who is entitled to know what all you took charge of, right? What was everything that you were responsible for, or that you are responsible for on behalf of this other person, right? So that has to be done. It has to be thorough, and it has to be done pretty quickly, and it does not have to be a chore. It does not have to be a chore, but it can become one fast if you don't get yourself organized from the start. So the first tip is for accounting and initial reporting is to set up a good record keeping system, and to do that straight out the gate. This does not have to be anything fancy. You do not have to set up a Quicken or a QuickBooks or or a big budget spreadsheet. You don't have to do all of that. If that helps you, great, do it. But you can get a little chart, or a little you can do your little Excel worksheet. If that's easiest for you, you can also do it longhand on a legal pad or a pad of paper. I have seen folks grab manila folders, and they just have a folder for for every category, and and get organized that way. But whatever is going to be, whatever the system is that is going to allow you to be consistent and accurate with keeping up with the records of the person that you are conservator for, that's going to be the best system. Okay. And the reason I'm saying to do this early is because as long as you are in charge of somebody else's stuff, you will always have an ongoing obligation to be ready as soon as the court asks for it to produce that accounting, to give that report to the judge to say, well, this is what the accounts look like right now. This is how much money we're expecting. This is how much we spent. This is what we spent it on, and so on. Another thing that's just really a practical point is, I mean, it's sad but true is how I have it in my notes. That is that frequently people who are older, who will get a conservatorship in place when they're older, frequently they will die with the conservatorship in place. And so if there is a probate proceeding that is necessary after they pass away, the financial information and stuff that you did in the conservatorship can really, in a practical way, start to just kind of roll right over into the probate. So I guess what I'm saying is, once you take charge of somebody else's money or property, you always have that charge until the conservatorship ends, right? That person regains capacity, which does sometimes happen, until another conservator is put in place. So somebody else other than you becomes the conservator, or until that person passes away. Right. And so this is not an obligation that is going to be less of an obligation as time goes on. It's actually going to be more. So get a system in place. Just get a system and get it early. And that
fast and in a hurry.
Yeah, and that way you can just maintain it over time, rather than what some of our clients are having to do right now, which is to go back literal actual years to find bank statements, to find receipts. Like, I can't even remember what I had for dinner last Tuesday, let alone where the receipt is for something that I bought. You know what I mean? Like, geez. It's right. So just set it up right from the start. I know I talked a lot about that, but yeah, please.
Just one other point on that is that, on that point of having it set up from the front end, like this is a thing that we talked about as you're getting ready for your initial filing. And that's why we spent time on it then, of just getting started right then, because number one, this accounting, that first one comes fast. So it's like usually within 90 days of your appointment that you've got to get this filed. The other thing about getting your system in place quickly and having it organized so that you can always be on track for your reporting here, that becomes important, is when you are in the situation like Jill's giving of our clients where we're having to go back years and put this thing together, it's because somebody has filed a suit in court to say, hey, wait a minute, I want some information. And so at that point, somebody else is controlling the scheduling and is breathing down your neck and is looking for you to get this done. And so it's one of those like mini projects, like doing it a little bit at the time is always easier than having to deal with the massive snowball and with somebody looking over your shoulder going, why isn't this done yet? Why isn't this done yet? And when is it going to be done? Yeah. So having that system set up is going to really set you up well for that to not be the situation you're in.
And it keeps the court out of your pocketbook because ultimately, as a
That too.
fiduciary, you have an obligation to make sure that you are not mixing up that other person's money with your money and you're using their money and property and resources just on things that are necessary for their care and so on. And if, like in the example that Alicia is giving, if somebody has gone to court and said, I want to know what's going on, it's not usually just because they want to know what's going on. It's because they suspect that you have done something that you were not supposed to do, or that you have not done something that you were supposed to do. And so when you are a fiduciary, right, and go back to the other episodes, if if you need more information about what exactly that is and what it requires, but if you are a fiduciary and you get that wrong, you mix up or mess up somebody else's money, then the court is going to be looking to your pocketbook to make it right. So do this. So get this right for them. Get this right for yourself. If you are not in charge of somebody else's money or property, but you were just in charge of their personal decision making, you still have some planning to do. The court is going to require you to tell the court what the plan is. And they call it, at least in California, they call it a general plan. This is what the person's care is going to look like. This is where they're living. This is what their health needs are. This is how we're meeting those health needs. This is, all of that. And there's usually, at least for us, there is a general plan form that that the court requires for basic information. Now you might have to, add on additional information, or frequently you do have to add on additional information, but at least start with whatever your court's form is at the start. And look at that to see what types of things you need to plan for, and you need to be telling the court that you have planned for. Here's a pro tip. If you remember when we were back at the beginning saying, hey, take that declaration, this was last episode, the declaration that the doctor needs to sign off on, right? To say that they've done the testing and what their diagnosis is and all of that stuff. Take that form with you to the doctor's appointment. Add this general plan form to the forms that you take to the doctor's appointment, because the doctor can actually help you with what the plan should be, and you can knock those two birds out with one stone, and the doctor will appreciate you for it too, because it means that they don't have to touch it again. So then there are some ongoing duties. How are we doing for time? Okay, we're about 47 minutes in. I think we can get this done. There are some ongoing duties after you're appointed. And so this is not a surprise, right? Because as long as you are in charge of somebody else or somebody else's stuff, your obligation to them sort of goes on as long as you're in charge, right? So the court, everything that you do as a conservator, you're going to be doing with court supervision. And so while a judge or a court attendant or bailiff is not going to be standing next to you when you do every single thing, they will require you to come back to the court on a regular basis, at least once a year, but a number of times more frequently than that, to report out on what you're doing, what you have done, what needs to be done, and the court will get to weigh in on that. So for financial and property things, we already told you, you're gonna have to provide regular accountings and reports. And these are things that that other family members will be entitled to see and will be entitled to ask questions about. So you want to make them you want to keep them organized and make them thorough. For personal care, things you might need to report to the court, like if the person that you're in charge of needs to move, for example, you need to, you have to to let the court know that. Sometimes you have to let the court know that before the person moves, and they need court authorization to do that. But a lot of times you just need to let them know that that's happened after the fact. There is in California, and likely in just about every other state, a handbook, a conservator handbook that really sets out a lot of this information. Is kind of like a reference manual. Just keep that handy. Just save a copy on your desktop, on your computer, or you can get a hard copy or print it out, because that's a really good go-to to have questions answered. But also, it tells you, at least the one in California, and frankly, even if you don't live in California, the California Conservator's Handbook is actually a really good one
Very thorough.
yeah, because it's really thorough. You can use it wherever you are. One of the great things that it does, is that it gives examples of what the reports look like. So you can just copy and paste and use that. Listen, plagiarism is an academic concept, so you
Yeah.
can
In,
be
in every other sphere, it's called Why Reinvent the Wheel?
right. So you can use that to help get a checklist and that sort of thing going, and keep yourself organized. One other thing, and I know we talked about this last episode, and I really think that it is useful here because to repeat, because you have ongoing duties. Set a meeting every single month, or I mean every quarter, if that works for you. I would say at least every quarter, but every month is probably easier because you get statements and that sort of thing, monthly. Set a meeting every month with yourself, just to reconcile, update the books if you're in charge of money, but also to update the care of the person if that's what you are in charge of. It is also a really great time to check in with the family. The more that people know about what's going on, and the more that they are able to be involved as much as they want to be involved, because not everybody wants to be involved like that. You're the conservator for a reason. And so, but if folks want details, if they want to know what's going on, it can really save you a lot of headache, both in the practical handling of the conservatorship, right? Rather than everybody calling you every 15 minutes or every other day, they know that they're going to talk to you at least once a month. So they're going to know what's going on. That tends to help people, be more confident and to be more calm. But it also really helps you in your duties with the court, to the court. To make sure that you're reporting out and you are keeping the court up to date on what is going on, because ultimately it is about the person you're in charge of getting what they need, getting cared for the way that they need, but it is also about keeping your butt out of the sling with the court, because a judge's favorite question to ask is, how come we didn't know about this before now? And that is a really uncomfortable question to answer. I don't care how prepared your answer is, it's always an uncomfortable question to answer.
Especially if you didn't know it was coming.
Right.
So you were unprepared.
Right. Last two tips are sort of along this same practical line. This isn't so much about getting appointed as it is about how to be set up for success once you are appointed. Let somebody know where your conservatorship records are in case something happens to you. Somebody needs to know where those records are in case something happens to you, because even if the worst happens to you, that person you were in charge of still needs their care. And so do that. And then also, If you don't have your own advanced healthcare directive, get one. And if you do have an advanced healthcare directive, update it to note that you have been appointed as the conservator for another person, so that if something happens to you, your healthcare agents know that there's somebody that you're in charge of, so that they can notify the right people, so that that person that you're in charge of can have continuity of care for their finances or property, or for their personal health and care. So, did I leave anything out? That felt like a lot.
No, I was just checking the notes and you covered all of the things. Good
Okay.
job.
All right. Well, we reached the last bullet point, y'all. See why we needed another episode? This was actually this was actually really detailed. We were putting when we were putting this outline together, we were just in there like, what's that character on Charlie Brown who plays the piano but he plays it like this? That was us. But hopefully this information has been helpful. Alicia, what were you going to say?
Well, it's just that I'm looking at our notes because we had so much in that we were scheduling for 2 weeks, and I'm looking at our next up note, and I'm like, wait a minute. And it's the whole lot of much caring for ourselves, and I'm like, but wait, can we do that again? Because it's still a lot of much.
We can.
So
We can. I'm game for
I
that.
realized, and I was going to say what's coming next, and I was like, oh, wait, that part of the note is outdated, but it still feels very current and relevant.
You know what? Maybe
So-
we can do that on Instagram Live. Maybe we'll do that there and keep the legal stuff here. Anyway, you all do not want to hear us plan for that. If you have questions or concerns, of course, go ahead and drop them in the chat box. But or you can email us. You can. Our email is dlg@dahlialawgroup.com. You can reach us at Dahlia Law Group on Instagram. I think we're at Dahlia Law Group everywhere: Instagram, Facebook, LinkedIn,
social.
all of that.
And on the internet, dahlialawgroup.com.
That is true. That is true. So if you have questions, concerns, you wanna reach out to us, please feel free to do that. Next week we will be right back here, 12:30 Pacific